Good morning and welcome to the David and David on Real Estate podcast. Today we are in episode number 158. Good morning and welcome back, David Korman. Always a pleasure co-hosting with you.
Good morning. Always great to be with you too, David. And 58's a lucky number for me. It's my year of birth, a number that I wore on the back of some uniforms that I wore over the years. So 58's always a good number for me.
Crazy. And all we're doing is adding a little one in front, 158, kind of a crazy number, but super excited to be here with you guys and for everybody tuning in. And I think today we have another very timely episode because we're talking about something that is very important in industry, something that I see a lot as a broker owner, and that is we're going to be talking about mortgage verifications today, which is a very important topic. And it's a topic that not enough realtors are really paying attention to it. So, David, why don't you give us a little bit of a background? Why is this so timely? Why is this so important? Why should every realtor really be paying attention to this?
Okay, what we're really talking about here is uh, a realtor that's getting a listing to sell a property. And it's really a question of making sure you do your homework before you take on the sale so you know exactly what you're going to be able to sell. Because most properties that are going to be sold have some sort of encumbrances on there. There's a mortgage, there might be more than one mortgage, there might be lines of credit that might be secured against the property. A lot of times people aren't even aware that their line of credit is secured and what's outstanding on. So sometimes they don't realize how much has to be paid out from the proceeds of the sale of their property. And sometimes there isn't enough funds to pay any mortgages, lines of credit, outstanding amounts to CRA, or something else that might be registered on title. Plus, you got to pay your real estate commissions, you got to pay your legal fees for closing. So, what we're really talking about here is doing all the math before you're taking on the listing to figure out if you sell it for X dollars, is there enough money to cover everything? Because if not, you have an issue and you have to deal with it other ways. So I think in a nutshell, that sort of might explain what we're talking about here, David.
That was a great explanation. And David, what happens if there's a shortfall? So what happens if the debts owing are greater than the sale price of the property?
Yeah, so we can't close, okay, without making arrangements to make sure everything is cleared. Because when we're going through the closing process, we get, if there's a first mortgage lender, we get a statement from the first mortgage lender. Here's how much is owed. Here's the principal. Here's the interest, any penalties, interest, right to the closing date or the day they're going to receive funds. They send a calculation. Same thing with a second mortgage lender. If there's a lien on title, we get a statement from each of them. If the CRA is owed money, whoever's owed money, and that's registered against the property, we're going to get a statement as to what those amounts are, plus the real estate commissions, legal fees. So we have to calculate all that. And if there isn't enough from the proceeds of the sale to cover it, we can't close, because we can't close unless we've made arrangements to pay off all of these things. So then we have to go through a process of there's two options. Either the homeowner may have other assets and they got to come up with the shortfall to pay it to their lawyer acting on the sale. So let's say you're $10,000 short. So they've got to send in $10,000 to their lawyer, because you need that 10,000 plus the sale proceeds in order to pay everybody what they're owed. So that's one option. And some people have other resources and have funds available. The other is, if that's not an option, is we have to go back and try and negotiate with each of the people that are owed money to see if anybody will take something less in order to provide a discharge of their security that's registered on title. And nobody likes taking a haircut on those things.
Right, because it's secured against the title, right? So if you allow for the sale to proceed, and David, there's also a situation where the lender can allow the sale to proceed by reserve their rights to come after the seller in a subsequent proceeding, and that might be a really good option.
Right.
Um, to get a partial discharge or get the funds back partially, but still reserve the lender's right to go after those people in the future. And are the lenders obligated to provide that remedy to sellers? Like, how does that work? What's the lender's obligation here?
No, the lender has no obligation to cooperate or do something like that. Okay, their lender's going to make a decision like that if it's in their own best interest. Because you go back to when the lender lent the money to them and the mortgage document was signed, and it's an agreement for them to pay them back the full principal and interest and their administrative fees, etc. So that's the contract in essence that's been signed by the two parties. So the lender has no obligation to take a lesser amount or to do anything. But lenders have to be practical as well. So depending on the situation, sometimes that's a reasonable option. And maybe we just put a number to it. Let's say it's $1 million property and the first mortgage lender had a $600,000 mortgage. And let's say we're short at the end of the day to pay out everybody by $50,000, just to put a number out of the air. Okay. So the lender could say, okay, I understand based on these numbers that you can only give me 550 out of the closing proceeds, but I'm owed 600. I'm prepared to provide a discharge to allow your transaction to close, but I'm not releasing the homeowner from their debt obligation because they've signed a mortgage, which is basically like a promissory note. They promised to pay me the full amount. So I'll discharge my security without prejudice to my rights to pursue the owner for the shortfall. So they still have the right to sue them and get a judgment against them. Or they might say, you know what, owner, I want you to sign a default judgment as part of this. So we'll release the security, but you sign a judgment. So I don't have to sue you and chase you. You're going to sign a judgment right now that acknowledging that you owe me the $50,000. And now I can use the legal process after that to see what other assets you might have and how am I going to try and collect on that 50,000. Okay. Sometimes the borrower might have direct assets that they can point to the lender, say, hey, you know what, get me off this, release your interest in this property, and I'll give you a second mortgage on this other property, or I'll give you some other security for doing it. Sometimes, a borrower has those kind of resources. Oftentimes they don't. And it might be, if I'm a lender, I say, okay, sign a judgment so I can pursue. So when you might have assets today, but you might have assets 2 years from now or 3 years from now, and I can drag you in once a year to examine you under oath to see what assets you have and see if there's a way for me to collect on the shortfall, as opposed to me as the lender saying, okay, I'm giving up on the shortfall. I'm taking 550 and, I'll take a haircut, I'll sign a discharge and move on. And lenders do that sometimes too, because they realize, they're not going to get water out of a rock.
Right. We had a situation recently where an agent listed a condominium for sale and they got notification that the lender was going to list it under power of sale as well. And then we actually procured an offer and there was a shortfall and our agents tried to negotiate with the solicitor acting for the lender, and they wouldn't budge on releasing their securities or giving any sort of favors to the then seller. But the interesting situation is that, contrary to my advice, the listing agent took a really small commission, and the offer was quite good given the market conditions. So it was interesting for me to see that, the solicitor for the lender wasn't willing to play ball, knowing that, they're saving a ton of money on commission, knowing that the offer is super strong. Don't they have a responsibility to mitigate some of the damages here?
Yeah, they do. A lender selling a property under power of sale always has a duty to mitigate, which means they have to go through a process to show that they got a reasonable fair market price. Okay. They can't say, oh, I'm owed 600,000, the property's worth $1 million. So if I sell it for, 650, I don't care because I'll get my 600. And I don't care who's, everybody else is left without money behind me. That's not the way the system works. They have to try and sell it for fair market value. Now, if they expose it to the market and go through a reasonable, multi-listing process and doing it, and the market happens to be bad and they can only get 900 out of it and not a million, but they've gone through that process and they sold it in February 25 when it's not a great market, then so be it. People will take a haircut, but they can't just take the first offer at any price. They have to go through a process. Otherwise, they're going to be challenged by everybody that is subsequent to that lender's interest. Starting with the homeowner, because their equity is being defeated. If there's a second mortgage lender, if there's a third mortgage lender, if there's anybody else that has an interest in that property, they will all hold that first mortgage lender to account for it. Show us your process. Show us that you went through some reasonable system to mitigate your damage, to get as much as possible in the circumstances, and not just accept the first offer to get you out. Because usually a first mortgage lender is going to get their money out, even in a bad market. More often than not, unless they lent 95% of the value at the time. If they're a reasonable lender and they only lent 65, 70, even 80% of the value, they're usually going to get their money out. Once you get above that, it becomes a little more iffy. But they still have to go through this process and try and sell it for a fair market price at the time.
Right, right. So David, if a realtor doesn't do mortgage verification and say they get themselves into a situation where they've sold the property, the deal is now firm, it's binding on the seller and the buyer, and we talk a lot about buyers reneging under contract. We never really talked about the situation of what happens when a seller cannot close because there's a shortfall.
Yeah. Well, that's a big problem, because basically a seller would be in breach of the agreement of purchase and sale, and the buyer will, in all likelihood, or potentially suffer some damages as a result of that, and the seller could be responsible for those damages, because if they can't close, uh, like they're preventing from the buyer's point of view, they prevented the buyer from buying another property. Okay, the buyer put their deposit, the buyer, signed a contract that's moving to closing. It might be a month later, 6 weeks later, 2 months later. So the buyer's out of the market at that point. So the buyer might suffer real damages, because if his transaction doesn't close, the buyer cannot just go find another property, similar property at the same price, and the market could shift, and that seller would be exposed to damages from the buyer because basically it's a breach of contract by the seller. Now, it doesn't happen all that often, but in these type of scenarios, that's where it potentially could happen, especially if the realtor's not doing their homework at the time that they're taking on the listing, to try and figure out what's the story here. What mortgages are on title? Are there lines of credit? Is CRA chasing you? Are there any construction liens or potential liens on the property? Has there been any physical improvements? And that's a situation that people get into all the time, David. As you get your advice of good realtors like you and those in your office. People are told to fix up their property before they're selling it. Do some repairs, do some painting, replace certain things in there. It might be the HVAC, it might be a roof, it might be a furnace, who knows what it could be. And they're hiring trades to do that, and sometimes they get in trouble because they don't settle with those people, and then the lien can go on the property.
Right.
So, and they might not even be aware of that, or not realize that a lien, oh, I'm just stiffing my trade for a period of time, and before you know it, there's a lien registered on the property.
Yeah, yeah. And those construction liens, they're not fun, they're not pretty, and you got to deal with them when they come in, right?
Right.
But I think the bigger issue here, David, as well, or I mean, an equally of a big issue is the fact that listing agents are responsible for the co-op commission in case there's a shortfall of commission payable, right? So that's
Mhm.
also something to be aware, is that you're not only creating a liability for the seller in a situation where they cannot close, you're also creating a liability for yourself in the brokerage, because the co-op commission is still payable, and it's still liable, right? Um, the buyer didn't default. They brought a willing party that is willing to close, and
Right.
they're owed the co-op commission on that sale. So be really careful. It's so important for you to do due diligence and run the numbers, ask for a recent mortgage statement. Ask if there's a second mortgage. Ask if there's a line of credit. These are tough questions, but you got to go through this process and really find out some background information and check and verify, right? Call the bank, send that mortgage verification form into the bank so they fill it out. Get a copy of that recent statement. These are your responsibilities as a listing agent to make sure that, it's all about bringing the transaction to a fruitful completion at the end of the day. And if you don't do this work at the beginning of your listing period, then you're not going to be successful to crossing that finish line.
Right. And the buyer's agent doesn't have the right to ask for, evidence at that point of what's outstanding on the property or any of that. They're really relying on the seller's agent to do a proper job, before they accept an agreement of purchase and sale. Because on the buyer's side, they're not going to find out until after the agreement is signed, when the buyer's lawyer searches title to see what's registered against title. But even that doesn't tell you what's outstanding. It'll just show, hey, there's a first mortgage that was registered for 600,000. It doesn't tell you that what the balance owing. It just knows, you just know what it was registered for at the time, or there might be a line of credit. Oftentimes, when we search how these days, even on a property with $1 million, something there's a mortgage on for the full $1 million value, because a lot of the lenders are doing these mixed mortgages, lines of credit secured by one registered mortgage, and they just register it for a nominal amount of the full value of the property. And that's just security for underlying loans. So on title, it might be registered for $1 million, but it might be there's a 600,000 mortgage that it's securing. It might be securing a line of credit. And then we go through a process to find out exactly how much is owed on it. But this is all after the fact. The agreement's already been signed, and we're moving towards a closing process. So, then we're going to get into it with, then a buyer's lawyer can insist on, we need a copy of the discharge statement. We got to start seeing the math and everything. But then we're just going to get to a point where, okay, there isn't enough money to cover all these things. Okay, seller, what's your plan? We're moving towards closing. How are you going to get these off? So there's a lot of work to be done if it's underwater. So you really got to anticipate this before you sign an agreement, because now you're exposing the seller to a breach of contract by the seller if they can't close and make all these arrangements. So really, this should all be addressed before a seller accepts an agreement of purchase and sale.
Yeah, and I think even a better practice is addressing all this before you sign a listing agreement, right? Part of
Yes.
your listing agreement, part of that paperwork. I think every prudent realtor should be explaining this process to the seller and saying, "Hey, listen, if you owe more money on the house than the house is worth, these are the possible repercussions. This is what's going to happen. This is, the default situation that you're going to be put in." And I think if the seller hears that explanation at the beginning of the onset, I think number one, they're gonna be more truthful with you about what's really happening. Number two, you're gonna get a very good indication of the situation that you're in, the background story. And number three, you're gonna be in a position where you are able to help that seller navigate the situation from the onset and bring it past the end line and a successful transaction. Versus if you avoid the topic, you're not going to get paid because you're not going to be able to close the transaction.
Yeah, you're either not going to get paid, or one of the first places that the seller is going to look to negotiate to cover this shortfall is the commission of the seller's agent, and maybe the buyer's agent as well, even though the buyer's agent is sort of innocent in this thing. But they're going to say, hey, there's 50,000 in commissions here. If I only pay 20,000 in commissions, I've got enough money to close. So there's my solution, right? And now they're putting pressure on the agents, that could be unjust. Now, if it's an agent, seller's agent didn't do their job properly, then then that's a natural place for a seller to look at. Hey, you should have figured all this out before. I haven't sold a house in 30 years. You should have done your homework and advised me on this before you let me get into this. Therefore, you're not entitled to your full commission. I think you should take the haircut on this to get this deal closed, right? So as an agent, I hate when that happens. You guys work so hard. I never want to see that happen. Don't put yourself in that situation. Figure this out at the time you're accepting a listing. Just ask the right questions. You're not being asked to do something out of the ordinary. That should be a routine inquiries. Okay, what are the mortgages on title, right? How much is outstanding? Are you in good shape with the CRA? Because if not, if CRA is owed, even though there's nothing on title, the next day there could be something on title that's going to take priority to everything. So you got to ask these questions.
Yeah.
Same thing with liens. Has there been any work on the property recently? Have you paid the trades in full? Is there any disputes? Like it's not a lot of questions to ask, right? But you're failing to do your job properly if you're not asking these questions.
Yeah. And of course, most agents think, well, we have a large deposit. My commission is getting paid from that deposit. But remember, the deposit is trust money. It belongs to the seller and the buyer in the transactions at successful closing. It doesn't belong to the brokerage, and it surely does not belong to you. So if
Right.
there is a shortfall, the lawyers are instructing us to, put that whole deposit into their trust account. And we don't see any of it. So don't think that just because you have a large deposit, that protects your commission in being paid. It surely does not.
Yeah, and you only get paid upon successful completion of the transaction. You don't get paid, you're not entitled to that commission because you got the parties to sign an agreement of purchase and sale that has no chance to close. You only get paid upon successful completion of the transaction. So you've got to make sure that the transaction can be completed. So you got to do your homework up front with the seller. It doesn't mean, some properties are more difficult than others. Doesn't mean they won't be able to sell. Sometimes there's different ways that we discussed of working these situations out with negotiations with the various parties, or maybe they have other means to come up with the shortfall or can provide other security. So it doesn't mean it can't close or the property can't be sold. It just means it's a little more difficult to sell a property like this than a property that has lots of equity in it, where it's easy for everybody to get paid. But you have to ask these questions up front and don't let your seller client sign an agreement um, when you don't have a map that outlines the plan for everybody getting paid.
Yeah, David, let's talk about that really quickly. So say that you're signing a listing agreement, say that seller makes disclosure to you and says, hey, there's, a whole bunch of money owing on the house. I'm not sure if it's going to cover the listing price. And say that an offer comes in very quickly because we're in the hot market. As the listing agent, you have to put a condition in that offer to give the seller an out as you're negotiating and doing your due diligence with these lenders. Is that correct?
Yeah, that's a great point, and it's sort of a bit of an unusual situation. Usually, it's buyers that are putting conditions in, right, for inspection, for financing, for things like that. But that's a situation where a seller would actually need a condition. They need an out because they might need a period of time to say, okay, if I get this purchase price, I've just sold it. I need some time to go back to my lenders or the construction lien claimant to figure out what I can settle with and make sure that I can accept this price and pay and everybody's on side for me to close. So that's a really good point, David. You might have to put some sort of condition for a period of time in order to allow the seller to go through that process.
Yeah. Well, everybody says real estate is so easy and realtors are selling all these houses and now more than ever when you're in a tough market, when there's so much change or there's so much economic change, you're going to see these situations, and I'm sure you guys are seeing it at your law office as well, where transactions are a little tougher to close. There's more involved, there's more questions to ask, and now more than ever, you have to have the right representation. You have to hire the best agents. You have to, hire agents that are going to do their due diligence, that are going to, do all their checks, because, there's a lot at stake here, and your house is your biggest asset. So get the protection that you deserve, and work with professionals that are qualified and will go that extra mile to make sure that you can cross the finish line in one piece.
Yeah, that's great advice. You need the right real estate agent that understands it, that can work these things out, that's got the experience. And I would also encourage you at the same time, when you're in these type of situations, you get the lawyer that's going to be acting for the seller involved in the process as well. Because sometimes we have an ability to get involved in the negotiations and the settlement to make sure if they do settle on a certain amount that it's all papered properly for exactly how much the lien claim is going to accept, or how much a mortgage lender is collect, or even how much the CRA is going to accept, because CRA sometimes will accept a lesser amount to allow a transaction to close, and usually that's without prejudice to their rights to come after the party at some future date. But you want to get the lawyer involved as well to make sure everything is documented and papered properly before you accept an unconditional agreement or waive conditions on it. Okay, so make sure, like David said, you get the right professionals involved in this situation.
Awesome, David. Well, this has been a great topic. I think it's very timely as well with what's happening in the market. So thank you for shedding some light on these issues. And anybody listening, any questions that you have, reach out to David Korman. Reach out to me. We'd love to hear from you, and we'd love to take your questions.
Okay, thanks everybody.
Thank you, everybody. We'll see you guys next time.